So you have what? And stop me if I get this wrong. Clerk magistrate's hearing, arraignment and bail, pretrial conference, compliance and election, trial readiness, depending what they're going to call it, final pretrial. I don't think I see that as much anymore. And then you have your trial date. If you can get that lawyer in advance to get you out of the stream before it even kicks off, again, as you point out, not going on your record's pretty big.
You use these green sheets when you want to dispose of the case and essentially take a deal. So my experience, the most common deal is referred to as a CWOF, CWOF, which stands for a continuance without a finding. All right, welcome to another episode of Boston Barristers here with Chris O'Brien. Today's episode will be about the stages in a criminal trial. First question, Chris O'Brien, what's the first thing that happens after someone's arrested?
It's a good question. A lot of things happen after you're arrested. Typically, though, you're going to be brought back to the station house and you're going to be booked. But if you're talking about the next step in the process, I guess it depends on the charges that you're facing because, typically you're going to see a bail commissioner and the bail commissioner is going to decide whether or not you stay in or go out, if you have to post bail. And then let's say, assuming you aren't able to make bail or you're not offered the opportunity to make bail, you're going to be held until they can get you into court for an arraignment and then a bail hearing in front of a judge. If you're released, you're probably released with a summons, which, is a request that you appear for your arraignment and for your bail. And there are, even beyond that, other ways that you can be brought into court. There are like sort of stages of criminal process that occur without arrest. We could talk about that to the extent that you want. I don't know, how much detail you want to get into about clerk magistrate's hearings or other stages. But where do you think is a good place to begin, Bill?
Yeah, let's talk about, as you mentioned, the clerk magistrate hearing. So you can be arrested or you can be summoned and then scheduled for an arraignment, but sometimes they don't go straight to the arraignment. They set up a clerk magistrate's hearing. So tell us a little bit about that. A
different third thing. Yeah, one of the things to understand is that there are so many different ways that a process can begin. There's never going to be one traditional one-size-fits-all manner that a person is brought before a judge and arraigned, which arraignment is typically considered the beginning of the litigation process in a criminal setting. And that's going to be true in district court and superior court, but there are always things that happen before that. There's always something that leads to the arraignment. So the clerk magistrate's hearing is something that can occur under different circumstances. It's going to typically be limited to misdemeanors. There's kind of a whole bunch of law that's not really worth getting into about when and why there's a clerk magistrate's hearing, but it's important to have a good lawyer during the process because if you didn't get a clerk magistrate's hearing when you were supposed to, that can be grounds for a motion to dismiss or other relief that you might be entitled to. Because what a clerk magistrate's hearing is, let's say someone calls the police and they say that a misdemeanor occurred and the police show up and it's over. And the person who is alleged to have committed the misdemeanor is not even there anymore. What happens? Well, based on how serious it is, the police could go out looking for the person and arrest them, which kind of would cover what we talked about already. But they can also simply issue an application for complaint. So an application for complaint is where the police do whatever investigation they're going to do, and then they will submit their documentation to the court, which again, it's an AC file. So an application for complaint is not criminal charges. It's a request that criminal charges issue. And so with the application, what that kicks off then is an opportunity for a person to get in and get ahead of the process. It's actually a really excellent opportunity if you have a good advocate, typically. You can do them on your own, but it's not recommended because it's recorded. And while it's under seal, a prosecutor could potentially get their hands on it. And anything you have said in the clerk's hearing could be used if you have to testify at your own trial. It could be used to impeach you, that kind of thing. So it can be helpful to have a lawyer at a clerk magistrate's hearing. I don't want to steamroll here, but I could just let you know what a clerk magistrate's hearing looks like. Do you have any questions about what I've mentioned so far before I jump into what a hearing is, a CMH? If you're facing legal trouble in Massachusetts, Whether it's an OUI, firearms charges, or even just a clerk magistrate's hearing, the stakes are high. This is not the time to go it alone. You need a lawyer. But more than that, you need a legal team that knows how to fight and knows how to win. That's why people across Massachusetts are turning to the law offices of Matthew W. Peterson. With over a dozen years of experience in criminal law, both on the defense and prosecution side, we've got the track record and the passion to defend your rights. If you've lost your firearms license, or you're dealing with family law or immigration issues, we've successfully helped clients and represented them in some of the most difficult situations out there. From first-time offenses to serious felony charges, we've helped people protect their record, protect their families, and protect their freedom. So don't wait until it's too late. Visit mwpetersonlaw.com to schedule a consultation or call 617-295-7500. That's mwpetersonlaw.com, 617-295-7500. Because when your future's on the line, you deserve a legal team that's all in. Stay informed, stay legal.
Yeah, you mentioned how important it can be. And while it seems like sort of an informal process, one of the most important things is that at this stage, if you can get it dismissed, it doesn't go on your criminal record, right?
Yeah, it doesn't even appear as a dismissal. It's sort of it's so pre-process, right? It's so before the criminal process begins, so far before, that it won't even show up on a criminal history as a chart. Because again, if you get to a clerk magistrate's hearing and you get the matter resolved without charges issuing, you've never been charged with a crime. And you could reliably say that. If you ever asked on a form or something for employment or whatever, have you ever been charged with a crime? And if you got brought to a clerk magistrate's hearing, you show up at a clerk magistrate's hearing, and the charges are dismissed, you could correctly answer, yes, I've never been charged with a crime. And so it's also beneficial because once you get into the process, the criminal justice system, unfortunately, can move at kind of an industrial pace. So once you hit arraignment, you are among 50 other cases that the prosecutor and the judge are looking at that day. And it's the most important case in the world to you, but it's pretty hard to distinguish between that for the people who are running through dozens of these every single day. And so once you're in the flow of the system, it's, you need a good lawyer to fight to get you out. If you can get that lawyer in advance to get you out of the stream before it even kicks off, again, as you point out, not going on your record's pretty big. So I know you're familiar with clerk magistrates hearings. How long? You said they're informal. So let me pitch it back to you rather than me just talking this whole time. What did you mean when you said informal?
Well, they seem informal because, in my experience, a lot of them don't happen in the main courtrooms. They happen in the side rooms that look like conference rooms. Everything is recorded. And it is official in a sense that there is the clerk magistrate there. But it seems informal in that the rules of evidence don't apply. And the clerks give broad leeway to attorneys and defendants, complainants to basically say whatever they want. And it's up to the clerk to distinguish what's reliable hearsay from unreliable hearsay and to make a determination as to whether or not there's probable cause, right? So there's three potential outcomes of a clerk magistrate's hearing. One outcome is that probable cause is found and the complaint is issued. Another outcome is that there is no probable cause found and therefore the complaint cannot issue. The third option, however, and probably the one I run into the most, is that the clerk magistrate will find a probable cause, but he actually is able to use his or her discretion to decline to issue the complaint anyway. And so in a lot of the clerk magistrates I do, let's say involving fake IDs, well, when the clerk magistrate is holding the fake ID, there is plenty of probable cause that you possessed a fake ID.
Right.
So at that stage, we're saying, we understand that there's probable cause, but we're going to ask you to use your discretion in light of all this other context about who the person is to not issue the complaint. So those are the three outcomes. But if the complaint is issued, then you have to go through the arraignment. So Chris, at arraignment, sort of what happens? Like what's step one? Let's say I'm a defendant. I have to go show up for arraignment. Step one is I got to go check in with probation, right?
Yeah, I mean, that's just like one of the procedural things, because if you don't, they're going to ask whether you checked in with probation. So you get to court, I'm going to check in at probation, say I'm here for an arraignment today, and they'll let you know where to go from there.
And why are they asking defendants to check in with probation?
I think because probation will be the kind of person who'll make determinations about indigency. So whether or not you would get appointed an attorney if you can't afford one. And you want an attorney at arraignment. You're entitled to have an attorney with you at arraignment. And so whether or not the justice system is required to give you that attorney is something that probation will tell the court. And you
Right.
are familiar with that as someone who has taken cases as appointed counsel. So you know what a duty day looks like, and you know what it means to be the duty attorney.
Right. So when the arraignment starts, it seems that essentially the process is, in every court I've been in, is they call your name, and then the defendant stands up and approaches the bar. And usually there's some microphone there, and they walk up to it. I'll walk over to them. I always like to stand by my clients. You don't have to. Some attorneys will stand up at the podium. I like to walk and stand next to my client. And then at that point, the judge essentially says, we're entering a plea of not guilty on your behalf. They read the charges out against you, and they say you have a right to counsel, et cetera, et cetera. You can hire one. You can have one appointed. If they ask for one to be appointed, one is usually appointed, whoever the duty day attorney is there. And then court essentially just asks, all right, what's the next date? So it seems like arraignments are pretty much just a check-in to start the criminal process. Have you seen much substantive stuff happen at arraignments?
So I think the thing that's substantive about arraignments that gets kind of washed sometimes is that it is in due process, as a concept. It's when you formally are made aware of the charges against you. And so what's odd, and the reason I said sometimes it gets kind of, we blow by it, is, as you point out, sometimes a judge will say, we're entering not guilties on your behalf. Counsel, do you waive formal reading of the charges? Yes. All right, thank you, goodbye. Let's our next date. And it's like, it all happens. Like I said, it's very industrial. So they move really fast. But what is supposed to happen, and then we see on TV, how do you plead? Not guilty, Your Honor. Like they skip over that. They assume they're going to enter a not guilty on your behalf so that you can have a chance to talk to an attorney first. Because what probably happens is people come in and they're like, I feel really guilty. I did do it. And it's like, you should have talked to an attorney before you open your mouth. So
Right.
They enter not guilty on your behalf, and then there's a question of whether you are formally arraigned, right? You can request that. I practiced in New Hampshire for a number of years, and we did mass arraignments where they would just rifle through, and a person could request formal arraignment where you would go up in front of a judge, and then the magistrate or the clerk of court would read to you, you've been charged with blank and alleges the following. And then they basically read the charging document to you, because that's what an arraignment is supposed to, I think, like in a textbook sense, an arraignment is they read the charges to you. Right. But it's become so streamlined now that a lot of times it really is, as you point out, just a kind of procedural touch point. Here's your lawyer. Here's the next date.
Right.
Now, sometimes though, what you'll have is, usually, unless it's an unusual circumstance, is going to be bail, right? I know you mentioned they'd say, what's our next date? But there's going to be a question of bail, which is typically pitched to the prosecutor, right?
That's right. And actually, so I forgot one thing. Sometimes when we show up to arraignment, we can actually do something prior to the arraignment. And it depends on...
You mean for disposition of the case, right? Yeah. This is a good point. I'm glad you brought this up.
Yeah, so there are opportunities for certain defendants to receive pre-arraignment diversion. And as we talked about, the reason why that's so important is that if they don't arraign you, it doesn't enter onto your record. So sometimes there's this gap where technically the complaint is issued from the clerk magistrate, but before the judge or the clerk reads the charges and you're formally arraigned, sometimes we're able to talk with the prosecutor or the DA's office about pre-arraignment diversion. And one case I've had this is I had a client accused of shoplifting. And that's not a major charge that is going to be destroying lives normally. But the issue in this case was that he was here as a student immigrant. And a shoplifting charge could have much more serious consequences for that person than it would a normal citizen in the United States. And because we didn't want that charge to show up on his record, so we wouldn't have to answer questions about it, we were able to ask the prosecutor if they'd be willing to do a pre-arraignment diversion program. And they were, because they looked at the potential consequences of a shoplifting charge on his record. And they're just way too severe for the conduct that he's alleged to have engaged in. So the prosecution said, okay, here's what we'll do. We'll give you a 6-month general continuance, which is basically just saying we're not going to start the arraignment. We're going to say we'll do the arraignment in 6 months. But here's the thing. If you just do 12 hours of community service before that arraignment date, we won't arraign you and we'll just drop the case entirely and it's not on your record. That's a pretty unique situation, and the person has to have pretty much no criminal background. The charges can't be very serious, but there are cases such as that one where we're able to actually accomplish something at or just prior to arraignment.
That's a great point, because it's another example of how even if you move past the clerk magistrate's hearing, if you have the right representation, and I say that only because I don't think these are the kind of things that are being offered to someone who's representing themselves. If you know well enough, you might ask. And if you have a prosecutor who's in a good mood, maybe they'll be like, you know what, we don't need to arraign you on this. But typically, there's got to be something that makes you stand out from that, like I said, stack of 10, 20, 50 files. And if if what makes you stand out is Bill Manchinton being like, hey, do you think that if he does some community service, we could just have this kind of held for 6 months prior to arraignment? So that's another great point about when you could try and keep the thing from charges issuing. And I appreciate that distinction that you brought up, because it's one of those things where even if the clerk magistrate issues charges, until you're formally arraigned, you've not been charged. So it's kind of like these technicalities do matter if it comes to the cleanliness of if you have do you have a clean record, or do you have charges that were dismissed? And this is a serious problem, I think, for people, because one of the things unnoticed, and a lot of people would be surprised to know, is that the consequences for just being charged with a crime are pretty steep. And so, you know, when we represent people, if there's any possibility we can avoid them being charged in the first place, it's usually something we put a lot of our energy into.
Right. And I think that's where a good lawyer or a great lawyer separates themselves from just the average lawyer. And I can say that in that specific case that I was talking about, when I first went up to the line prosecutor and I said, hey, can we do something pre-arraignment? She was like, no, we want to take shoplifting seriously here now, so I'm going to arraign him. And I didn't accept that. I said, oh, you know, I kind of pulled a Karen, not going to lie. I was like, well, let me speak to your supervisor, because I need to provide some more context here.
I can't believe that really worked.
Isn't appropriate for an arraignment.
Yeah.
So, and I did speak to her supervising prosecutor, and he agreed with me. And if I didn't take that extra step to be like, no, I'm not going to just accept what the line prosecutor says. If I didn't do that, then he would have been arraigned and it would have been on his record. So if you have an attorney that's just complacent and just sees you as another file and doesn't want to fight for you in that way, or is afraid to make waves with the prosecutor, you're not going to get the same results. So when you're trying to sort out which attorney you want to go with, make sure you find someone that's going to fight for you in that way.
For sure. I actually want to make sure, I want to try and paint a small picture for people, because I think it would surprise them to know what it looks like when you walk into court. And there's going to be tables for defense counsel. There are going to be, you know, lawyers who are there for their clients. And then there's the table for the prosecutor. And when I say there's like, I'm not joking that when I was a prosecutor, I'd have 50 cases, and you have 2 banker's boxes full of paper files. And I was in court on Monday in Haverhill District, and it was a large table covered in just like shingled, you know, manila folders. So because with all the names, and 2 prosecutors basically seeing these files for the very first time. And each of these files is going to have police reports, witness complaints, evidence, all this other stuff. And I think the thing that would surprise people who don't have exposure to this system at all is how this is conducted at such a breakneck pace, right? So when you talk about going to you say, I go to the line prosecutor. What that means is you kind of walk over to the desk in the middle of open court and say, hey, I'm here for, you know, Jane Doe. Do you have a minute to talk to me? And sometimes the answer is no, and sometimes the answer is yes. And it can be beneficial for them to be able to tell the court, look, I talked to defense counsel and here's what we're going to do. But they're looking at all these folders, and you got to say, pick that one out. And I want to talk to you about that person. And I have a proposed plan for how we should handle this case. And if you can do that, you can streamline things a lot. And I mention that because it also is like the last piece I want to talk about for arraignments, because we've been on arraignments for forever, it seems like. I feel like the other stages we could probably move through faster because they're more like check-ins. Whereas this is like the way everything gets rolling. And that is, and I'm drawing at least in part on my experience as an assistant attorney general, where an arraignment is the first chance to get discovery, right? And if you are called to a clerk magistrate's hearing, you're summoned to a clerk magistrate's hearing, you can, and it can sometimes be easier for your lawyer to get the discovery that's attached to the case. I've had people, say, hey, I'm told I got to go to East Boston District Court for something that happened in January. What is this even like? I don't even remember where I was. What's this about? We file an appearance. We tell the court we want the information. We get, oh, this is a bar fight. Do you remember being in a bar on January 12th? Like, oh, okay, yeah, now I know what this is about. You get that discovery, that police report, and now we know the strength of the case. You get an experienced attorney, they read that thing once, and they know the strength of your case. And more importantly, the likely trajectory for once it gets into court. You knew, seeing that shoplifting, that you could probably massage a really good result for the client, because that would be in the interest of justice. And when you were told no, you were like, nah, I still have a strong feeling about this. So you go over their head, which again is risky, but you got to have the right lawyer to do it. And then you get the result that is appropriate in that situation. In a much more serious case, you're going to look at that police report and say, well, no, there's no prosecutor's going to let this go. And, discovery is an interesting thing, because as I just described, there's this breakneck pace in most district courts. The Attorney General's office largely does superior court cases. And when I would show up at arraignment, I have investigated a case for 2 years, and I've been in front of a grand jury half a dozen times. And I have a hard drive of evidence to hand over, along with a notice of discovery, which is going to itemize every single solitary thing that I'm handing over to you. Frankly, by the time, at least with the Attorney General's office's practices, my discovery was typically done. Like, I was done, and by the time you're arraigned, I'm all set. You're going to get everything you're going to get.
That is foreign for me in the district court level.
Right? Because district court level, you're lucky if they have a copy. They're supposed to have copies for you, but sometimes, I told you I was in Haverhill District on Monday. This was the second hearing for that case. So I already had the arraignment, and I was there for a pretrial conference, and they were like, we still don't, discovery is not complete. Like, I have CDs I have to burn and give to you. So I guess just the way that these things, it's not trying to, mystify this whole process, except to say that there's no 1 through 10 list that I could write for you, for anyone. I don't think anybody could write that would accurately capture how this process works. It has so many different places that it can go in different directions. And the only way to really know how it's going to be is to have seen it, right? Like, to see the permutations that a particular case can take. What's the particular branches that this thing's going to follow? Do you got anything else on arraignment, or you think you want to move on to whatever else can happen next?
Arraignments, let's say that there's two outcomes. You could be either held because the court says that you're a flight risk, so you're still in jail. The other outcome is that you either make bail or they release you on what they call personal recognizance. The next step is to go to your pretrial hearing.
I don't want to judge. So I feel like we have to at least say something about bail, right? Bail could be an entire podcast, Bill.
I know.
As you and I both well know. Bail is a huge, huge thing. And it has consequences, not simply for what happens to you at bail, but what can happen to you after your case is over. Stuff like if you're serving time on another case, or if you're awaiting trial on another case, should you have bail in this case? If you are released on this case, but you're held on another case, what happens when you get sentenced? These are all things that happen pretty regularly. And if you don't have an attorney who is familiar with best practices, then you're at risk for not putting yourself in the best position when your case ends. The last thing I would say, because I think we touched on it maybe 10 minutes ago, is that there will be a question of bail, right? The judge will ask about bail, and the prosecutor will indicate what they're seeking. And that can range from personal recognizance, which means don't commit any new crimes. And basically, sometimes there are other terms that will attend to recognizance bail, but you're released on your own responsibility. It's kind of the way to look at it. There's cash bail. Cash bail is a pretty hotly debated topic. And there's, as an even more complicating factor, there's something called surety, right? So you can either post bail of your own, or a bail bonds person can post for you. It's becoming less and less common these days. But again, subject to a whole different podcast. Usually that's going to be a lot higher, and you're going to have to pay the bonds company some amount of that anyway. So you have cash, corporate surety, recognizance, and then there's the There's the no bail hold. And no bail holds are a pretty rough thing in Massachusetts because sometimes they're pursued frequently. I had a 58A hearing a few weeks ago where it's an entire evidentiary hearing to determine whether someone is so dangerous that they can't be released, even on a GPS bracelet, cash bail, you name it. And if you are facing something like that, you absolutely need an attorney. Like I've said this, I think I've said this on other podcasts that we've done. I would not represent myself if I was in a 58A bail hearing. Like, and I've prevailed at 58A bail hearings. And when I was a prosecutor, I conducted dozens, if not hundreds of bail hearings. And I would not represent myself. It's just not a good idea. You need someone who's like, you need a second brain. You need someone who can speak for you. So your statements on the record aren't being attributed to you. So bail's a serious thing, and again, a good lawyer should be able to kind of predict for you, or at least work out with the prosecutor. Because the other thing, it's discretionary, right? I mean, some DA's offices have policies where for certain crimes, they always ask for a dangerousness hold, and that can be dicey. But, whether they're going to say cash bail or personal recognizance, maybe it's good to have a lawyer there who will say to the prosecutor, who will advocate for a specific bail request. And then whatever request, the bail is set by the judge. Right. So the prosecution will request a certain thing and the judge will make their ruling. And that's true all the way from recognizance to a no bail hold. And so you need a lawyer who can negotiate with the prosecution or advocate against them on your behalf with the judge. So that's bail.
Just to put a nice little bow on it, the purpose of bail for the court is what?
To ensure your appearance at future court proceedings. There is the sort of ancillary security purpose, right? So if you have this person's a danger to the community and can't be released. And the terminology there from case law is something like, there are no conditions short of keeping this person in jail, which could reasonably secure the safety of the community or themselves. And so that's a lot, right? I mean, if you say like, well, we could put them on GPS with an exclusion zone. So like an alarm bell will go off somewhere if they leave their house or if they enter a neighborhood where a victim lives. So for a judge to agree with the Commonwealth, not even that's going to keep people safe. Like, it should be a high bar, but these things get cleared a lot more often than you'd think. If you get struck with a no bail hold, you'd be in jail for 120 days and possibly longer. It's tough. And so it's important to get it right the first time. I appreciate putting a bow on it. I think you can segue by saying that changes to bail can happen at any time, for the better or for worse. So that can keep coming back up, but it's going to be set at your arraignment. The initial bail will be set.
So the next date, basically at the end of the arraignment, after the bail arguments, all of that, defense counsel asks for a date. We get to pick the date, right? Because it's our calendars. Prosecution's going to be there every day anyway. So we get to pick like 30, 45 day timeline, usually in my experience. And so the date is called the pretrial hearing date. And if you look at the rules, there's supposed to be this like pretrial conference that happens between defense counsel and the prosecution. And it's supposed to happen before the pretrial hearing. And it's envisioned that I'm going to like sit down with the prosecutor at a table and we're like talking about the case and what we want to do with discovery. But in my experience, it doesn't really happen that way. Pretrial conferences and pretrial hearings basically get combined into the same event in my experience, which is I show up on the day of the pretrial hearing with my client and I walk up to the prosecutor with a pretrial conference report, which is a sheet of paper with a bunch of information on it and boxes to write stuff in. And essentially what happens is I ask the prosecutor for X, Y, and Z. I say, all right, well, I want the body-worn camera that you guys should have. I want the surveillance video. Any evidence that we're looking for. The prosecution has a duty to automatically disclose that evidence to us, but I itemize my requests anyway, so there can be no confusion as to what I'm looking for. And I give them that sheet, they sign off on it, and then that's pretty much the pretrial conference. In my experience, at the district court level, it isn't a true conference where you're talking about the case. It's more like I'm handing a piece of paper to the prosecutor, requesting discovery on XYZ items, and then we go from there. But according to the rules, at the pretrial hearing, the prosecution's supposed to already be giving me all of the discovery. But it doesn't really work like that in practice. Like you said, at the superior court level, you were already done with discovery at arraignment most time. At the district court level, it seems like although the rule says automatic discovery is supposed to be turned over by a pretrial hearing, I think only one case I've got where one guy, the prosecutor, gave me everything at the pretrial hearing. And I commented on that. I was like, wow, you guys are on top of it here, I guess. But most of the time, as you were talking about earlier, they have 100 cases on their desk and they just can't be that on top of it to give me discovery way in advance. But anyway,
I'll editorialize if you want, because I have kind of a couple of different points that kind of to color what you just talked about. One of them is that, again, talking about Superior Court and the AG's practice that I was a part of, when you get to a pretrial conference, you have a 10-page memorandum that you have typed. It's not a double-sided sheet of paper you picked up in court that morning and scribbled on it. And you try to get that document to defense counsel prior to the hearing so that they have a chance to agree or do their own. And it really is supposed to map out, if this goes to trial, here are the potential witnesses. Here's how long I think the trial is going to take. Here's the outstanding discovery. Here's like any motions that I've spotted that I'm going to want to have the court litigate in advance. And so it serves a much more robust purpose, I think, at Superior Court, at least in my experience, than it does in District Court, where it really is, as you point out. And I mean, look, I'll use that example from Haverhill, where I was there on Monday. It was the prosecutor whose hands the case was in for the pretrial conference was a different prosecutor from the person from arraignment. So the person in arraignment, when they stood up in court, it was the first time they'd seen that file. At the pretrial conference, first time that person had seen that file. So that the court's saying, is there any discovery outstanding? And the prosecutor's got to go through the thing they've never seen this before. And they're going to say, it looks like we still owe some discovery. And so that all this is recorded, right? It's all on the record. So there's an audio recording of this hearing. So if there was ever an issue about when discovery was known to be incomplete and what was outstanding. It also helps because if we get a day before trial and they pop up with some new discovery, it'd say, we didn't even know this existed until today, right? It was all this record of who knew what and when. But fundamentally, the problem is that where these things, they all are supposed to serve a purpose, but until you could prove actual prejudice, non-compliance with the purpose, it doesn't really seem like it has a lot of gravity in court, which is kind of a weird segue into something we are not talking about today, which is PC dates and 30-day dates. Because, the stories I always heard when I was talking to people about their experience as prosecutors in district court was PC1, PC2, the judges are fine. But by the time you get to PC8, PC9, these are hearing dates that just occur where the government's not ready to move forward with a case.
Cause, I assume.
Yeah, so you could talk about all the different permutations that a case can take, but I feel like PC dates are the reason I called this a neat segue to a thing I didn't want to talk about is where you talk about how a pre-trial conference doesn't serve the purpose it's supposed to. Now that it's a PC hearing date. Mm-hmm. We well know most attorneys, because it's so disregarded, will not bother.
Okay, real quick. Probable cause hearing, like what is it supposed to do? So we're in district court and for some reason they put a probable cause hearing on the schedule, on our calendar. What is that?
It's supposed to be an opportunity for the defense, I guess, to challenge. It's a requirement, due process, for the government to present probable cause to support the charges so that the prosecution can continue. And what will happen is when they get to court, they'll say, we're not ready to have a probable cause hearing. Can we get a 30-day date? And the court will say, okay, we'll try again in 30 days. And if that sounds crazy to you, it's because it is. And if you have a lawyer who objects and says, my client wants their probable cause hearing today, on the probable cause hearing date, the court will say, well, let's try again in 30 days. And it's one of these weird immovable objects in district court. And that's why I didn't want to talk about it, because it's like, it is such a pointless pro forma thing now that I'm not sure what purpose it serves besides the fact that the legislature and the courts haven't gotten around to eliminating it yet. Maybe because they couldn't justify eliminating it on a due process ground, but it's completely disregarded until you get to like PC8, PC9, and then the courts are like, are you ever actually going to move forward with this? And what can happen is, a lot of times, if it's a serious offense and the person's being held, the prosecutors are like, well, I think it's going to get indicted by a grand jury. And that's a probable cause finding by a grand jury that will see the thing moved into superior court. So we really shouldn't do this now. We should wait till it gets indicted. Problem is, like, look, you've already started in district court. You shouldn't have started this prosecution if you weren't ready to prove probable cause. And now you want to keep delaying it to give yourself more time to indict. And, I have a lot of sympathy for prosecutors because I was one for so long. And I know that they have so many cases to move. But and I think that this is just one of those examples where the justice system kind of shrugged. They're like, well, we'll deal with the PC problems on an as needed basis.
Mhm.
But I mean, probable cause, interestingly, just again as a callback, is what we talked about in the context of the clerk magistrate's hearing. Because the clerk magistrate's, the burden on the Commonwealth at a clerk magistrate's hearing is probable cause, which is, depending on who you ask, and its formulation is facts and circumstances would lead an ordinary person to believe, or a person of reasonable prudence to believe. It's a low threshold. Probable cause is lower than preponderance, which is the next step up, which is 50-50. The probable cause is lower than 50-50. And that's still something
Right.
the
That's
government will...
I feel like that's the thing most clients have a tough time understanding, and I have a tough time understanding, because you hear the word probable, right? And you think, well, if something's probable, it's got to be 51%, right?
Right. It's like probable cause to believe that it could have happened. And probably,
they should change it to plausible cause. You know what I
mean? Yeah, sure. That would be less confusing. Although the transition would probably drive people to distraction. You know, it's one of those things where it's really, I mean, the way that I always understood it when I was prosecuting was, it's like, did you even present any evidence? Because that's when you get into like motions practice on like motions to dismiss, usually what the rule you hear in case law, or and the thing that people who know what they're doing will recite, is that any reasonable inference can be made from the evidence with the in the light most favorable to the non-moving party, right? So it's sort of, you always give the benefit of the doubt on the evidence. So what's really awful about this, and I think what the people we represent struggle with, is it's like, this seems like it's not credible, right? We have all this there's so much evidence I have to rebut it, and it's like, well, in a probable cause study, they're just going to say, is it reasonable? Like, could it be? And you know, are they making a reasonable showing on all the elements of the offense? So like an example would be, if it was breaking and entering nighttime to commit a felony, and it happened at 12 p.m. Well, now that the nighttime is not supported by probable cause, because there's no allegation that it occurred at night, and so that's an example where you wouldn't get it. But again, if it was like a toss-up as to whether or not it was nighttime, and I think there's actually instructions on what constitutes nighttime, but the idea is that if is a toss-up on the elements, it's going to go in favor of probable cause. So low bar. And now I'm glad that we had a 10-minute diversion on probable cause I want to talk about, but I think we're good on pretrial conferences, right?
Right. So we got the arraignment, then the pretrial conference / hearing. So that's step one. Step two, what's happening after the pretrial hearing? What's the next date?
Well, assuming you can't get the pretrial conference, you can't get it disposed, because sometimes that's a chance for the prosecutor to be like, wow, I don't really know why we brought this case. I would, if your client wants to plead to sufficient facts, usually I think they'll just offer like, how about guilty probation? You're like, all right, thanks for nothing. Because then at some point we could talk about, and we should talk about, green sheets and pleas, defendant capped pleas especially. But then so let's say you're at the pretrial conference and the prosecutor says, discovery's not complete. You say, okay, well, we need a compliance and election date, which is a fancy term for, we're going to come back in and see if discovery's done and figure out what happens next.
So the compliance part, so it's the date's called compliance and election. And the compliance is referring to what?
Compliance with discovery obligations.
Complying with the discovery obligations. Okay, so what's the election part?
So the election is, I think, this is supposed to refer to whether or not this is going to be disposed of. It may even refer specifically to whether or not you were like a bench trial or a jury trial, because everyone's entitled to, under the right circumstances, you're entitled to a trial by jury, right? That's just baked into the Constitution. You can waive that, and you can have the trial in front of a judge, which is called a jury waived trial, but you have to enter a waiver of the right to a jury. And so there are a number of different ways that can go, but that's, I think, you elect whether to plead guilty or go to trial, and in front of whom. That's my sense of what election is supposed to represent. This is also the time frame under which, if you have a good attorney, they're going to be doing what's called a motions practice. I guess reasonable people can disagree about how long you wait to do motions practice, because sometimes in district court it may make sense to wait until you get closer to trial. In superior court practice, typically my experience is you try to get this stuff dealt with as soon as you can. And it's almost like a chess game in a sense, because if you can get certain evidence ruled on in a motions practice, like months before trial, like, this evidence is not coming in. This evidence is coming in.
Mm-hmm.
People who know what they're doing will say, okay, well, trial's not going my way if that evidence comes in. Or, I can only survive if this evidence is excluded. Classic example is going to be motions to suppress, right? So if the police are supposed to serve a warrant on apartment 1A and they kick in the door to apartment 1B and they find a bunch of cocaine, and now you've been indicted. That's ripe for a motion to suppress the evidence for an unreasonable or an unconstitutional search, right? So if you can get the evidence excluded, then there's no case, right? So then the case just gets dismissed because there's no way that they would be able to proceed without it. It's called a dispositive motion to suppress because it would have a dispositive result on the outcome of the case or the triability of the case. So, it can be really good practice to try to file motions to suppress if you're a defense attorney. And, the sort of other side of that is motions in limine for prosecution, which is them trying to make sure specific evidence gets admitted at trial. So those are an example of some motions hearing. And then why I mention this now, because if it's in this gray zone between the pretrial conference and trial date is when you're going to see motions hearings get scheduled, probably more likely in Superior Court, because I think in District Court, and even sometimes depending on the case in Superior Court, they'll deal with the motions at trial. If it's a dispositive motion to suppress, maybe you want to have, and it's going to require live testimony, you're going to have a hearing date where there's going to be officers usually called to testify. Your lawyer will cross-examine them, that sort of thing. But this is all really vital to your case. Because we talked a lot at the beginning about how you can get the case dismissed at a clerk magistrate's hearing without charges. You can get it kicked prior to arraignment without charges. Once you've been charged, you could still get the case dismissed by making it unprosecutable. And the way you do that is with a good motions practice. So that happens in this interim period. I suppose the other things, different courts call them different things, but you can have a trying to think of all the different ways I've heard this in my career. Final pretrial, the trial readiness conference, which is sometimes, depending on the court, held either basically the day that they're supposed to do trial, or really it's supposed to be a couple weeks in advance, because it is supposed to be what it sounds like. Are you ready for trial? And that's, your last moment to try and decide whether or not you're going to go forward. So have you had cases disposed at trial readiness conferences, final pretrials?
Only a few courts that I've been in will do the trial readiness. Been scheduled to one trial readiness, and at that trial readiness, we did a green sheet. So maybe this is a good segue.
Tell us about the green sheets, Bill. Tell us about the green sheets. Why do we call them green sheets?
So green sheet is, well, first of all, we call it a green sheet because it's printed on green paper most of the time. There it is.
Green sheet
He's
right
got
here.
an example. Perfect. And so what that is a tender of plea. So there's a few different options on there, and you check a box. One will be guilty plea, where you're saying, I did it 100%. But there's another option on there called admission to sufficient facts. And that's going to be probably a more common option that people select. And you use these green sheets when you want to dispose of the case and essentially take a deal. So in my experience, the most common deal is referred to as a CWOF, CWOF. Which stands for a continuance without a finding. And so essentially what that is you take one of these green sheets and you check off the box that says admission to facts sufficient. And what happens is the prosecutor stands up and reads the facts of the police report into the record. Then the judge turns to your client and says, are those facts true? And your client has to say, yes, those facts are true. And what that is the admission part, saying, okay, there are those facts I just heard in the police report. They're true. And if the prosecution were to go to trial against me, those facts alone would be sufficient to find me guilty. However, it's different than a guilty plea in this way. The judge says, okay, I heard that there are facts sufficient, and I heard that the defendant just admitted that they're true. But instead of just hitting you with the guilty right then, they say, all right, we're gonna put this on pause. Like, I could find you guilty, but I'm gonna put it on pause. And then the judge kind of hears both sides' recommendation. And sometimes there's an agreement, sometimes the recommendations are different. So the prosecution might say, okay, Your Honor, we agreed to a 1-year probation. And then defense will be like, yes, we agree to that 1-year probation. Or defense might say, we don't agree with the 1 year, we're recommending 6 months probation. Then the judge ultimately makes the decision. So the judge will be like, okay, Commonwealth, I see your recommendation for 1-year probation. Defense counsel, I see your recommendation for 6 months. What I'm going to do is sentence them to or put them on 8 months probation. And how this is different than a guilty plea is, so you go on that 8 months probation, and there could be conditions, right? So say if you had a violent offense, but the judge thought that that violence stemmed from issues with alcohol or drugs. The conditions of that probation may be random alcohol and drug screening. And the idea is that if you are able to complete that probationary period, the judge and the court will dismiss the case at the end of that. Basically, just a big picture it again. Client says, I don't want to go to trial. It doesn't look good. I want to see if they can give me a deal, but I don't want to plead 100% guilty. There's this middle thing called the CWOF. The defendant admits to facts sufficient for a finding of guilt, but the judge says, I'm not going to find you guilty here today. I'm going to put you on probation. And if you complete that probation, we're going to dismiss the case. Completely dismissed. However, here's the catch. If you violate your probation, what happens is the judge can sentence you immediately to whatever they want. First, there's a hearing to determine whether or not you really did violate that probation. And at that hearing, the probation department has a burden to show by preponderance of the evidence that you violated that condition. So let's say one of the conditions was to not drink alcohol. Well, if you had to take your alcohol breathalyzer and it showed that you were drinking, well, now you violated your probation. You go to the court, and then the judge can say, yep, all right, you violated it. Now you're guilty. So the dismissal's off the table now. Now it's just a straight G for guilty on your record. And I'm going to sentence you to whatever I want. The judge can sentence you to whatever the statute allows. So like maybe you were just on 6 months probation, but the statute allows the judge to sentence you to 2.5 years in a house of correction. They could do that. So that's probably the most common outcome of what we call the green sheet.
I want to jump in and build a kind of a chronology for when you're going to see a green sheet. So what typically, as I understand it, you can correct me if I'm wrong here with your experience in district court, that what's going to happen is when you show up for any particular hearing where, I mean, I think, again, what seems to happen most commonly is you show up for either trial readiness or for trial. And depending on the case and depending on its severity, again, these got to be caveats to everything I say here because different cases get treated differently, right? But for an example, I'm thinking of a case right now where the alleged victim in the case, very unreliable, right, has never shown up to court historically in other cases. And there's some concern about, their accusations being spurious and sort of unsupported and not particularly credible. But based on the charges, the Commonwealth's going to go all the way to trial. And what's going to happen is on the day of trial, they're going to stand up and say, hey, is Jane Smith here? Jane Smith? No, Jane Smith. Sorry, Your Honor, we're not going to be able to do the trial because we can't proceed without Jane Smith. And we told her to be here. And she's not here. And then the court will say, well, I'm going to dismiss this for want of prosecution. And then the case is dismissed. And that happens with surprising regularity. However, if that is Jane Smith is here. Okay, well, it looks like we have a trial on our hands. Well, Your Honor, the defendant, in light of the fact that we can have a trial, the defendant would like to know what the court would do. I'm kind of like trying to explain what's going on under the surface here because there's all going to be different language as is talked about. But what happens is that you can say then on your client's behalf, or the defendant will say, what would you do if I just pled guilty? Like if I told you I did it, judge, what would you do? And there is space for this because it's in the interest of judicial economy for the judge to say, well, looking at everything here and hearing from the Commonwealth and hearing from your attorney, if you were to tell me that you did it, I would appreciate your honesty in taking responsibility for this. And in light of your lack of criminal history, I don't really think we need to have a trial. If you tell me you did it right now, we will skip the trial. And I'll enter, you say you did it. Okay. And you talked about this, Bill, right? This is sufficient facts. And it really is effectively a plea. But I dealt with this a lot more in Superior Court, and I got really buried in some of the case law language, is you effectively tender a plea and the court doesn't accept it. Or they hold it and they say, okay, so I'm going to hold on to this for a particular period. And I'm going to continue, instead of entering a finding of guilty based on your plea to sufficient facts, instead of entering a finding, I'm going to continue it without a finding. And I'm going to do that for a period of whatever, 1, 2, 3 years. And if during that time you can abide by the conditions, then blah, 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 blah. There are different permutations of this, right? We've talked about a lot. There's like so many different ways this can go. But district court's unique in that it has what the courts call a defense capped plea or defendant capped plea. You could go beyond that. You could say, Judge, I'm willing to plead. You probably wouldn't do this, but you could say, I go all the way up to pleading guilty. And the reason you wouldn't do this is because let's say, it's just keep it in the world of reality here. You say, Judge, I plead guilty if you would continue it without a finding, because then it gets dismissed if I can stay out of trouble for a year. So I do a 1-year quaff, and the judge says, okay, deal. Then you get your 1-year quaff. You do we have the whole proceeding and what have you, but you've essentially controlled the outcome of your own case, or your attorney has. You can say, Judge, I'd take a 1-year quaff. And the judge says, that's not really enough time given your record and given the seriousness of the offenses. How about a 3-year quaff with conditions? And if you don't like that, you say no, and you go to trial. But if you say, you know what, that's really not that bad, I'll take it. The reason it's called a defendant capped plea is because it's an opportunity for the judge to voice what they would do to avoid a trial. Basically it. And what's crazy is that this can happen right next to the prosecutor who's like, they want to have a trial, they want you to be convicted, they want you to go to jail, and then you and the judge are like, we could probably work this out, right? And you say, Judge, I would say that I did it if you gave me a 1-year quaff. The judge says, no, I think this is going to be a guilty misdemeanor. Say, well, then I'm definitely not telling you I did it. But you could sort of like bait them by saying, if I pled guilty, what would you do? And it's defendant capped. So you always can take it back. And if the judge says, it's a great way the reason it's again allowed is because it encourages judicial economy. Let's say the judge says, you know what? No, this is going to be guilty, but I'm not going to send you to jail. I might actually just take that.
Right. And I think the ability to take it back.
Bingo. It's huge. There's a corollary to this in Superior Court. It's called the judicial lobby. And I think we're talking mostly about district court today. I think originally we intended to talk about the stages. I feel like Superior Court can be its own. I mean, it's not especially different, but there are sort of different names for things, and they're, have different gravity, and they're, more serious inflection points for a case. But the beauty of the green sheet is if all else fails, you could sort of throw yourself at the mercy of the court and see what the judge does. And if the judge is not amenable, like let's say you're like, listen, this felony conviction will cause me to lose my job. Would you do something else? And if the judge says no, you go to trial. You don't lose anything by trying to see whether it can be resolved with the judge. You see if it can be resolved with the prosecution. Failing that, can you resolve with the judge? Failing that, let's go to trial. And you need a lawyer who could do all these things, right? Because the last thing you want is a lawyer who can wheel and deal with a prosecutor and with the judge. And then when it comes time for trial, they're like, I don't really do this. I pass paperwork and I shake hands, but I really can't deal with a jury. Then you're in kind of tough shape there. So green sheets, dispositions, trial. I feel like at this point, the only thing we really didn't discuss in any detail is a motion to dismiss. And I kind of touched on that when I mentioned, the standard, the Di Benedetto or McCarthy standard, which is a light, most favorable non-moving party. And I mean, motions practice is its own podcast, Bill, so I'm not going to let you drag me down into getting into one of my favorite topics, which is motions practice. It was a little, I think we kind of slid into home plate there at the end with the way that we talked about green sheets and trial. And I will certainly not be talking about trial on this podcast. That is a much longer form discussion, I think. Maybe you guys can invite me back to another episode of Boston Barristers. We could talk about the glory of trials. We could also do another one on motions practice, but this was really supposed to be about stages. And I think maybe the best thing we could do now is just recap, right? So you have and stop me if I get this wrong, clerk magistrate's hearing, arraignment and bail, pretrial conference, compliance and election, trial readiness, depending what they're going to call it, final pretrial. I don't think I see that as much anymore. And then you have your trial date. And again, we talked about this a couple of times. Not every trial date's a trial date. Sometimes it's a plea date. Sometimes it's a non-binding trial date. Sometimes it's, we'll say it's a trial date. And if the witness doesn't show up, the case just gets dismissed. Right. It's a trial date, but we're not ready for trial. It's a trial date, but oh boy, we just got new discovery. So, there's exceptions to every rule, probably more exceptions than there are rules, frankly. The takeaway, I guess, is that until you've experienced it, it's, I think I said already, I wouldn't write a 10-point list of all the things that can happen because it would just be so misleading and so incomplete. Mm-hmm. The thing I've kind of around the edges, I've sort of talked about how different courts do things different ways. Sometimes they call things differently. Sometimes different judges in different courts, in the same court, will have different procedures they'll tolerate, different things they like to do. And so there's no replacement for experience being in a court of any kind. And that's, I've practiced in a bunch of different jurisdictions, but some things are uniformly true. They may be called by different names. For example, the defendant cap or the judicial lobby, or what you talked about with a CWOF. There are all these kinds of things in different states, in different jurisdictional settings, but they all track generally to the same interest, which is going to be balancing defendants' rights against judicial economy and the rights of the Commonwealth and the interest of the Commonwealth. And hopefully the interest of justice, if we can get it.
Right. That's a luxury sometimes, but
it shouldn't be a luxury, but it's something we're always in aggressive pursuit of. I feel like you have to have the knowledge and the willingness to fight. You need the energy to fight too. I mean, we didn't do a bio. I feel like I've been on the podcast once or twice before, but like I started my career as a tax attorney. And then after a number of years, I took a pretty serious pay hit because I needed something more interesting than what I was doing. And so I became a prosecutor, and I did that for 7 years. It got me out of bed in the morning, and I really enjoyed that work. And what I've enjoyed most about being a defense attorney is getting into court. That gives me energy. And I think it's the same way. In the time that I've worked with you, I get the same vibe from you. It's stressful, but you get a lot out of it. You get a lot out of the fight of being in court.
Oh yeah. Way more fun than the civil stuff. Civil stuff, arguing about, is it going to be 200,000? Is it going to be 170,000? And then you argue about that 30,000 difference for 6 months, and you don't step into court ever. I don't know. I didn't feel
there's
like
a place for it,
to be honest.
There's a place for it, and there's a very specific. I think there are people who are great at it, and God bless them. But it's not. It's not my strong suit. It's not where my experience lies. And I feel like these days you basically live in district court. Every time I hear from you, you're like stuck in court again. Like to court. The judge dragging me back in, I got it. The prosecutor needs this, that, the other thing. It's
never a dull moment. Never a dull moment. You got to say that. It keeps you on your toes. Meeting all sorts of people, seeing all sorts of shenanigans. It's good. It's awesome. Yeah. I love it. All right, Chris, we got our wacky hypothetical of the week. Would you rather do 10 arraignments in a day or spend an entire week doing trial?
I think like any good lawyer's answer, it depends. But to not try and wriggle out of your wacky hypothetical, Bill, what I'll tell you is I've done both and more. And what I would say is that personally, I prefer to have a trial. Although that is a week-long trial, people who do trials will tell you, anything that lasts more than a day can really wear you out. And you can knock out 10 arraignments in an hour. So, personally, I like the jury trials. Arraignments are a little more pro forma. Give me a jury trial any day of the week. For a whole week if you want. I don't care.
Yeah, I'm with you. I feel like if you don't pick jury trial, probably shouldn't be doing criminal law. Like, I don't know. The arraignments are, you could do 10 arraignments in 20 minutes if the clerk's on top of it. But the reason why we do this is to get into the battle of trial, right? And if it's a week long, you are going to war. And there's going to be a ton of witnesses. It's going to be stuff popping up that you didn't really prepare for, and then now you got to kind of like switch real quick and be like, oh, I didn't know this was going to be such an emphasis. I feel like that's where the money is made, right? In trial, that's where
the crazy thing about trial is it's so highly choreographed, especially jury trials, because in a bench trial you can do stuff and a judge can be like, I'm just going to ignore that, let's pretend that didn't happen. Where the jury, they say stuff like you can't unring a bell, you can't put the toothpaste back in the tube, like once it's out there. So you have to be really careful, and like things are highly choreographed in jury trials. Things are kept from juries on purpose, and like it's for how highly choreographed it is like barely controlled chaos a lot of the time, because like who knows what's going to come out of a witness's mouth. Right. In theory, we're all supposed to know because it's supposed to be in a witness statement that you get before trial. But who knows? And then once it's in the hands of a jury, anything goes. So it's an interesting thing, to be sure. It's a really fascinating way to practice law.
Well, there it is. Trial over arraignments. I think we're on the same page.
All right. Well, thank you for having me on the podcast, Bill. I appreciate it.
Yeah, absolutely, Chris. Always a pleasure. You are a wealth of knowledge and have tons of experience, so you are a great person to have on this podcast. That wraps up another great episode of Boston Barristers. Looking forward to seeing you in 2 weeks for our next episode. Thank you.